The listing of information.
May I please, Your Lordship, I beg to mention item number 4, my lord. I have given the adjournment slip, my lord, yesterday. So this matter, may I pray for listing this matter after the vacation, my lord? Obliged.
Lordship, I did mention item number 9 to 13, my lord. 9 to 13, my lord. Lordship, my senior is unable to appear today, my lord. His father has expired, my lord. Yes,
SB Laskar
I am
is in
instead of-
bereavement, and thus a request is made to adjourn the matters. List after Puja vacation.
most of them.
May I please, Your Lordship? My lord, I beg to mention for listing of my my lord, for restoration of a MAT appeal, my lord. The agency hearing is
Mat appeal
for
goes
rest-
before the other bench,
my lord.
not in this bench.
Please, Your Lordship, I'd like to mention for listing of a writ petition.
Ask.
My Lordship, it's against the SURFACE Act, and the my Lordship, bank may take possession of the suit property any moment, so it may be listed tomorrow, my Lordship.
All right, tomorrow. Everyone knows what is the fate of the surface rate petitions. Still, you don't hesitate trying your luck. Anyhow, it's your choice.
May I please, Your Lordship, Lordships, I am praying for listing an admission matter, which is very much urgent in nature. My interim order was continued by a single judge. Lordships, because there was an interim granted by the, while issuing not interim granted regarding appointment given by the respondent authority by violation of the procedural guidelines, Lordship.
So what do you want now? You already have an interim order. So
Yes,
you have an interim order. Why appeal lies?
Lordship, interim order discontinued, Lordships.
Discontinued.
Lordships. Tomorrow I am praying for Lordship.
All right, list it tomorrow.
Well, may I pray for listing of the street appeal tomorrow, my lord? It's against the rejection of an interim order by the honorable single judge. It's a tender matter.
When was the order passed?
It was passed on 9th, but.
So then there is no urgency, gentlemen. No.
We have got it after 2 days, and the government council, he submitted a written instruction before the honorable court. That took time when we applied for the certified copy, and Lordship will see from the records, when we applied for the certified copy, we got it, my lord, just 2 days ago, my lord. And we prepared and our entire matter.
All
is
right,
on the-
let it be listed.
Obliged.
May it please, Your Lordship, I beg to mention item number 17, Lordship. In this case, appellant filed one additional affidavit, Lordship, that may come on
Who has
record.
filed the additional affidavit? State.
Lordship,
So what do you want?
so that may come on record, Lordship,
So you want it to be taken up today or what?
today,
So
Lordship.
we'll get the affidavit, don't worry. Affidavit, get the affidavit from the office.
Obliged.
Lordship, I beg to mention item number 2 of today's list, Lordship. My senior informed me he's unable, Lordship. He is unable to appear before this honorable court.
Item number 2.
2, Lordship.
Why is unable? What has happened?
He's suffering from viral fever since last
Stated that the arguing counsel, Mr.
MR Chaudhary.
M.R.
I'm MR
Chaudhary.
Chaudhary on behalf of Mr. Ayed Sekia.
Mr. Arguing counsel is Ms. Saikia.
Ayed Sekia, Lordship.
Saikia is unwell. A request is made to adjourn the matter. List after Puja vacation.
Highly obliged, Lordship.
The entire list has been adjourned.
May I please, Your Lordship?
Yes.
Lordship, I am back to mention item number 15.
Yes.
Respondent authority file affidavit in opposition, will file reply.
When counsel for the affidavit in opposition has been filed by the respondents, counsel for the petitioner raised for time to file an affidavit in a reply. List of 4 weeks has paid. Yes, that it has to be taken up at 10:30. Ms. Saikia is here. We can take it right now. Yes. Ms. Das. Yes. Ms. Das, we have checked the record.
Yes.
Your submission is not correct.
My-
Original list, there were 33 candidates. Fresh list again, there are 33.
My lord, my submission was that, my lord, 26/9.
There was a verification.
Yes.
Malad total 43 numbers came up,
Verification was of 26 only.
26-9, Malad.
Yes.
Malad,
How many
there
candidates?
43 numbers of candidates they check, Malad.
Yes, yes.
And they found as per the report, they say 27, that report is there, Malad, 25. In
25.
any case, my lord,
It is assuming it is 25 or 27.
27, my lord.
So the verification was only of 27.
27
Assuming
they
their case.
found correct.
Yes.
But the admission given, my lord,
Is of
32,
33.
32. 32. More, 5 candidates more, my lord. And I have given the list of that yesterday, my lord.
Yes. Ms. Saika,
Their last page, kindly see.
How do you explain
We
this?
have given that. We are handed over that document.
no, these can be checked by the
We'll check it.
documents
Lordship.
available on
And
record.
whatever he is submitting, it is not in my humble submission correct.
May you
Because
explain?
total we have
That is why
verified
we
is
request-
43.
That is
Not-
why we requested you to stay back.
Lordship.
We wanted an explanation to come. Total candidates who appeared for
43.
verification were 43.
43.
Verification was of 25 only as per your list.
27.
20, assuming it is 27.
27 were found to be correct,
Yes. So how admission was given to 33?
not 33,
Yes,
30.
33.
The last 3 are for dental college. Their counseling is yet to take place. If lordship is pleased
List
to-
is 33, Mr. Saika. We have checked. Let us see. We can always
page
recorrect.
114,
Yes,
page
114.
117, lordship will kindly come.
Yes.
31, 32, 33, lordship will see the right hand column, government dental college
So-
Silchar,
All right. How 30?
30.
Yes. How 30?
How 30, lordship now? We have given that list, lordship will kindly see.
Yeah, 114. No? Well,
No.
today you have given this.
Yes.
Yes, yes.
Yes.
Hmm.
Lordship will kindly see to serial number 1, serial number of candidates who were found to be eligible for TGL in the observation and findings of the 26-9
Yes.
regarding 43 candidates. They
No,
appear-
no. Which document are you reading?
The document lordship will kindly,
This compilation you have given today,
yes, lordship.
serial number 1, yes, who are found to be eligible.
Who-
Yes,
And the serial, then these are 16.
okay.
Who are not found to be eligible are 16.
Yes, so 27
Then-
plus 16 makes it
Then next
43.
lordship will kindly see the
Yes.
third one.
Hmm.
Candidates admitted who were otherwise found to be ineligible by the SLLC,
Hmm.
but were admitted pursuant to the honorable
Yes,
court.
Vishaka Chandravanshi, that candidate was given that extra leverage. That
Yes,
is the candidate. Yes.
yes, lordship, that is the order of 27.
Yes,
Nice.
yes,
Then
that's right.
next page, lordship, in case of Saini Bhuya, in
Saini
terms
Bhuya.
of lordship's order of 20, division bench order,
Is
29.
there, which is the order, page 7? Let's see,
page 7.
just.
In the meantime, the operation of the notice dated
Hmm.
28, we had, lordship was pleased to, so we gave her.
Yes,
Then third one is
Saikya.
Vaibhavi.
No,
Yes,
the
Saika,
order
just-
is, my lord,
just turn 1 minute. Now that makes the things very interesting. If this order was communicated to you, can you claim that the other entire full stay was not, as Mr. Gogoi yesterday said?
It was lordship,
Miss-
they thought
Miss-
that 4 are to be stayed in respect of the 4 persons who
Miss
appeared before this.
We have serious reservations on your associate counsel. He was supposed to convey it very clearly that there is a stay on the entire order. We have expressed our displeasure yesterday also. And that is why we held you back. We now don't have any reliance on your associate counsel. If with all due respect at our command, we are not at all now.
There was some
Accepting his word.
miscommunication. He said that that order was
Yesterday, what he said was that because the writ appeals were not numbered, I could not communicate. That is what he said.
his whole intimation was regarding 4 that they have to be given admission.
Saikya, our order was
Madam.
uploaded the very same day. The very same day the order was
Lord.
uploaded. In this matter of such a sensitive nature, what was expected from the standing counsel for
Lord.
such an important department? You tell us, please. What you would have done if you were appearing in the court? You would have immediately conveyed to the officers that it is a state, you are not supposed to issue any fresh list. That was the intent, clear intent of this court's order.
Lord.
No, whatever
Now,
has been
and-
done. Okay, now let's,
Then next is
Look, what
Tasa Vaibhavi.
next is Pasha Vaibhavi.
Tasa Vaibhavi admitted.
how she has been admitted? There's a writ order by the
Order
next
dated
court.
29/9.
And there is no such order directing her to give admission.
Yeah, let's see, let's
Yes,
see.
look.
Page 11.
Harry, go for it.
Tasa Bhairavi, page 11,
Hmm.
and the order, as the writ petition has already been admitted in MBPS under the OBC, under this earlier interim order, the admission made shall be made final. Paragraph 7, last paragraph, sub-paragraph,
Hmm.
page 14.
Mated to the petitioner be made final. But this is a candidate of OBC, NCL, not of
Yes,
TGL. That's
yes,
like,
yes.
this list is only pursuant to the TGL as ex-TGL.
In the report, it is TGL lordship. I am coming there.
No, the order doesn't reflect so.
For the purpose of the-
The whole case is relating to TG. OBC also comes under TGL
No, no,
also
no.
comes under OBC.
Ms. Saikia, this is a different category, OBC, NCL. Please make the things clear.
So she also appeared in that verification
Verification,
process.
let's check
Yes,
if her name is there.
yes.
Let's check. All right, in this list at 115, where is the name of Tasha Vaibhavi?
Yes,
Yeah.
I'll place it. Lord.
That's right.
Page
Page
85.
page
85.
115,
Serial number-
115,
Page 85.
Serial number 13, my lord.
page 115,
Now, page 85, her name is there.
85.
Yes. Enquiry
second.
report, page 85.
Then
No,
Yes.
Tasa Vaibhavi, T Vaibhavi. And
just a minute.
as per report of the OCs, this is Sonitpur. Motok Tea Estate is not a Sonitpur district. Also, the NCL certificate provided is cancelled on re-verification and the matter is sub judice in Honorable High Court, WPC so and so.
It's at page 85. no?
85.
What happened, what the committee did?
Committee found that is the remark of the committee on the.
This is the remark.
So Ms. Saikia, her status was not verified
It,
as a TGL.
it was verified and it was found that she actually does not belong
So,
to that district.
TGL certificate is not verified. That's a clear indication.
So one thing is very clear. She claims that the tea garden is in one district and got the certificate from another district.
Saikia,
So that
whatever
was
the
the-
exercise, whatever the,
That was found out during the re-verification process.
so re-verification, let us check the numbers which the state level committee has approved, 27. Where is the list of that 27 candidates?
Yes,
Can you please explain one more thing, Ms. Saikia?
Lordship.
Come to page 81,
Lordship will kindly 81.
81, please.
Lordship. Observe 80.
After careful examination of the report,
Submitted by computer 25. There is actually it is 27. They corrected it at 26. That also because from the contemporaneous record, that is why today's our chart says Lordship 27.
okay. So we assume that it is 27.
27.
You have checked, we presume.
Lordship.
Now, what is the observation for Tasha Vaibhavi?
Tasa Vaibhavi Lordship will find that serial number 12
12,
at page 85.
yes. So
So her
Committee-
certificate, the fourth column Lordship will see certificate of TGL XCGL community issued by ADC Sonitpur, dated nil. That
yes,
certificate issued by Sonitpur district dated 17/6/2023. These were the documents they
so
submitted.
she is not affirmed to be a candidate of TGL
No,
category.
she was not,
So then how in that list of 30th September, she has been given admission?
because that
She was, if at all, she was to be treated, that was in the OBC NCL category, not in the tea garden laborers.
Lordship, now the thing is that there is an order of the learned single judge, which have
That is to confirm her admission in the OBC NCL. So one more seat falls vacant.
And moreover, my lord, page 92, very interesting. Page 92, serial number 37, 38, 39.
Hmm.
Page 92, my lord,
Yes.
of the SLC report, how they say, my lord, page serial number 37,
Hmm.
Vinayak Burma, my lord.
Yes.
The kindly see the report, right side, my lord. Although report of manager Silkori Tea Estate.
Cannot be established,
Yes,
hence could not be ascertained.
yes,
And
and
he has been given admission.
yes, my lord, at serial number.
Because that is why
serial
Lordship
number
was pleased
14.
to say that, Lordship was pleased to stay this order, these findings.
Saikya, if
Then
you are going by the stay,
No, we
then
have-
the list could not have been disturbed. Please don't take dual stand.
No, we are not taking.
Contrary. If you said that this
Now-
list is stayed,
These orders were there of the judicial authorities. These orders.
Which one?
Whatever we have now, in respect of Prasad Vaibhavi, there is an order of 29-9,
Not to give
In
admission,
respect
but
of?
to consider.
base 11,
Tasha,
Tasha.
yes.
The each individual I am addressing now.
So that's what we are discussing. Tasha has been treated under OBC NCL category. So how she could be a part of this list wherein you are granting admissions to TGL and slash
But I'll do.
XTGL. Please read the order. Ms. Saikia. Read the order at page 11. There are two things which are coming out. One, your representation before the single bench on
No,
behalf of the
Lordship,
state was
Lordship will
very
kindly see
poor.
what his certificate she submitted. What certificate she submitted, Lordship
Ms.
will see
Saikia,
the
please,
This
Ms.
is subject to
Saikia,
verification as per the, Kumar.
please, just, Mr. Das, will you have patience?
Lordship will
trying to
kindly
understand.
come to page 85.
Just before that, please come to page 11. What does the single bench order say?
Single judges order.
Yes.
1 minute. Yes, Lordship, Prasad Vaibhavi.
Clearly OBC NCL, nothing regarding TGL, XTGL. And the direction is also very clear.
If the learned single judge has not mentioned that TGL, Lordship,
No.
Lordship will
Yes.
kindly come to, we have to reconcile it with page 85.
Please come to para 7, Mr. Saikia. Before
The
we go
petitioner
anywhere.
Also directed immediately approach the director for doing the necessary formalities. The director of medical has to take note that there is already a declaration by the court as regard entitlement of the petitioner for a non-creamy layer certificate.
And para 6 about that.
In view of above order dated 21/8/2023 by the Deputy Commissioner Sunitra, by which the OBC non-creamy layer certificate of the petitioner was cancelled is set aside. Accordingly, the earlier certificate issued by the Deputy Commissioner Sonitpur dated 5/7/2023 is declared to be valid one. Now here the issue is like this. Lordship will kindly come to page 85 for a moment.
Yes, sure.
First, Lordship.
80.
82's column 1, 2, 3, 4, 5, fifth column.
Observations, remarks.
Documents submitted on 22/9/2023 before the SLC.
Yes.
Then Lordship will kindly come to page 85.
Mm.
The certificate number 1,
Mm.
certificate of TGL, ex-TGL community issued by ADC Sunitpur, dated nil. Then caste certificate issued by Sunitpur district. So two certificates are required. One is that TGL OBC certificate. The other one is that non-creamy layer certificate.
So
Our whole
there is-
case before the.
there is a clear finding, Ms. Saikia. When she comes to the single bench, she challenges the cancellation of her NCL category,
Exactly.
right? And the relief is granted only to that extent. There is no pleading that she wants an admission in the TGL. And your
The
observation,
NCL certificate.
please wait. Please, the finding of your committee is very clear. As per the report of the DC Sonitpur, Matak Tea Estate is not in Sonitpur. So our certificate was for Sonitpur. There is no such tea estate. The finding is conclusive, no TGL category. How could you have your director granted admission in the TGL category?
Now, she has given us the OBC TGL certificate.
NCL, Ms. Saikia, that was cancelled.
No, OBC as well as TGL.
TGL is a reserved category, a different category. OBC is not a reserved
Lordship will
category.
Kindly then take our rules.
Yes.
The rules, I am not sure whether it is before this honorable.
No, you read it.
Yes.
No issues. Yes.
The notification of 17 July 2023. Children of ex-tea garden or ex-tea garden communities or tribes TGL or ex-TGL, including within OBC, MOBC, non-creamy layer quota seats. What certificates they have to give? The original certificate of OBC mentioning the specific TGL community. So
Okay.
we have to look at her certificate.
Yes.
Specifying non-creamy layer status issued by the concerned deputy commissioner. May I
Yes.
please?
Let's see.
Because her OBC certificate is also indicative that she belongs to TGL.
That is all right, but TGL you have not verified, Ms. Saikia.
Her whole issue before the learned single judge, the subject matter was whether she is entitled for NCL or not.
NCL, that's what we are saying.
Lord,
So that's what ultimately comes out. It boils down to that, Ms. Saikia, that she is not treated to be a reserved candidate entitled to reservation under the TGL category. She is entitled to reservation under the NCL category. She challenges the cancellation of her the NCL certificate. The other matter which you addressed the other day, certificates of both parents, income of both parents, that was taken into consideration. And that is the precise finding of the learned single judge.
here also same, paragraph 3,
Yes,
page 13.
that's what we are saying. That yes, all right. You treat her under the OBC NCL. We are not bothered.
Lordship will give that observation, whatever
Ms.
category.
Saikia, that is very
But
clear.
when she entered, because her OBC certificate also indicates she belongs.
Her
to the-
initial entry was under NCL, which was rejected because of cancellation of the NCL certificate. That is a short controversy in the writ petition, as we could make out from the order you have placed on record. So her admission was required to be made under the OBC NCL.
Lordship, fine. Now,
Yes.
this is the position
Mm.
that she should have been given admission in the OBC category, not in the OBC TGL.
NCL, yes.
So in that case, the one person will have to take out from the OBC.
Whether, yes, obviously. So it is
let
whose
that
fault?
issue be agitated, appropriate,
Ms.
all the
Saikia,
parties
whose
will be
fault?
heard.
They are coming out with a case, or rather we are of the observation that once we had stayed that exercise of the re-verification, you were not supposed to touch the TGL seats. Your director has acted beyond.
Lordship, we have done a mistake.
Yes.
Is it not curable? It is curable.
We are asking
is
you that only. We are asking you that only.
Yes.
How to cure it?
How to cure it, Lordship?
Yes.
So for that, all these parties has to be before this honorable court, as
Obviously.
the
You see-
earlier round of litigation, the
you see that-
affected parties were.
That
not part.
candidate is not going out for the reason that she will have to be placed under the OBC NCL category only.
Then one seat, one person will have to.
All
because
right,
there's a-
now let us do another exercise.
Yes.
The original list of 8-9, wherein there were some results reserved. That is at page
Yes.
3rd September, Annexure 12. Is this candidate there?
I'll just check, Lordship.
Yes.
It is.
Let's see the roll number. We'll get it from there. You would never admitted her provisionally in the TGL category.
No, it.
Read please. What is the name? Page 12, Annexure 12, 51,
22.
51. Page 51. Page 51, Ms. Saikia. What is the roll number of this candidate?
39.
You got Annexure 12, Ms. Saikia.
Lordship, annexure 12.
Page 51. So this is the list
Yes.
of the
Original.
original list, 33.
51.
So this candidate is not there in the original list of TGL and TGL category.
Hardly, it is there.
Let's see. That's if it is there, then
It is
there's-
there. It is there. Which the name is not
yeah,
indicated.
that's why we are asking. What is the roll number?
Roll number, I'm just giving, Lord.
Yeah, we'll check. Ms. Das, do you have any idea about the roll number of that candidate? Maybe in the order is there
455.
455.
No, no, there is a long name, long number. T will be 1404060053.
Page 115.
Yeah, it is there.
It is there.
Is there?
It is in the witness.
JMC Jorat
Yes,
14010600053.
53. That is, and Lordship will kindly see.
It is there. It is there. That's what
Yes.
we wanted to
Yes,
confirm.
Lordship.
So if it is there, Mr. Das, so she gets the benefit of our order also.
My lord, my prayer before your lordship.
You see, your client, Mr. Das,
Yes.
still there is a seat available. Don't worry. But the exercise, what we are trying to find out,
My lord.
whether there has been a blunder beyond what has been noticed. Yesterday, what you said was that admission has been given to more candidates. That's what we are verifying. So it makes it clear, Vaibhavi gets in by any way, by any means, either the order of the single judge or our order. Now, thereafter, let the confusions be cleared.
On the page 92, if lordship peruse for a moment, my lord.
Just a minute. All right, Vinayak Verma, there are three
37 serial number Binayak Burma.
Yes,
Although report of manager Silk Ocean Tea Estate submitted, since a lineage cannot be established which predecessors here
but there is an order, there is an order of this court.
would not be accepted.
Vinayak Verma, we have passed the order. Yes, that is the first order whereby we stayed everything.
Yes, my lord.
Yes.
And 38
So Vinayak Verma gets it.
serial number 38 also, that could not be ascertained. 39.
Oh,
my lord, not-
Mr. Das,
my lord.
we have passed that is the main order
My lord.
whereby everything was stayed. So Vinayak Verma gets it there.
Lord, therefore, my lord, I pray, my lord,
Hmm.
my
Yes,
submission
your,
dated, my lord.
your candidate is again TGL.
Yes, TGL. my lord.
Okay. Mr. Saikia,
I am ready for.
so
my
that
re-verification.
fourth seat which now remains, on that he can be given?
Huh?
Because we have
Yes, yes.
Only
observed,
thing is that lordship,
yes,
my humble service, there are certain other candidates also who are in the
We have-
same category.
in merit,
But they have not come before this honorable.
in merit, that merit has
On
to,
merit, whatever is to be given for them. Lord.
whoever is there in the merit
Yes,
of those who have been deprived
yes, Lord.
because of that order of single judge,
Yes, Lord.
then a fresh merit will have to be prepared.
Yes, Lord.
Whoever stands in merit,
I
the
feel
fourth seat will
because
go
the
to him.
genuine and deserving candidates. should-
Fourth seat will go to that candidate.
Only one seat is left.
Yes. Okay, so we'll pass that order.
My lord.
Let a fresh merit be prepared amongst the other candidates who have been deprived, and they will be given
My lord.
the admission as per.
In my case, my admission should maybe upheld, because admission given on 7/9.
So, Ms. Saikia,
Already given, my lord, admission. College was-
she was also admitted as a matter of fact. So on merit, obviously. So now,
Let her continue till the exercise is done.
Yes,
And that undertaking lordship.
the undertaking, of course, everyone has to give.
I will prove.
All right, let's not go into that merit issue because
Yes.
earlier she stands selected on her own merit.
Yes,
Lord.
All right,
deeply obliged, my
order
lord.
pass.
Obliged.
And Ms. Saikia, you need to issue an advisory to your associates that whenever these sensitive kind of orders, they should be brought to your notice. They should be brought to your notice. That is imperative. If it had been
The
done,
earlier lordship, the normal thing is that in every case I appear. Now I have there is a notification that I do not appear before that particular court.
but these admission matters, if not you,
Single
at
judge,
least,
before division bench, I can appear before my lord.
at least some additional advocate general should be assigned. If you can't appear, that has to be there.
Only because
Because you see the reason we are telling. Many a times, we don't go by finding any fault in your associates on that count. Maybe the persuasion which comes with experience, that also matters a lot. Had it been presented in that manner, had Madhuri Patil been properly brought to the notice of the judge, this situation would not have been created. So maybe you can take it up with the state authorities that in important matters, they have to be assigned to the, if you can't appear because of any preoccupations, at least
No, it was
additional.
not because of preoccupation, lordship. In
We,
that case, I cannot appear because there's a reservation in appearing before that court.
okay.
There's a notification of this honorable registry also.
At least an additional advocate general should be there.
Lordship.
Okay, so we grant her provisional admission in same lines as the other candidates. Re-verification will be done strictly as per Madhuri Patil. And thereafter,
Lordship.
whatever undertaking she has to give. All right.
Highly obliged.
Deeply.
Thank you.
obliged.
Now you can proceed to Meghalaya. Okay.
Orders item 1.
Yeah, please, your lordship.
Yes.
Lordship, respondent number 10 has filed an IF for vacating still, my lord.
Hmm.
I will be allowed some time to file our objection.
What is it, Mr. Manta?
My lord, that regarding neighborhood, question of neighborhood, my lord, the fishery was settled, my lord, by the landed single judge order passed in my favor. That was paid by dishonorable court. And regarding my lord neighborhood issue, and that is my lord, the question. And my lord, that.
Where is the order passed, order of say?
Passed by page 20, my lord.
20.
Page 20.
All right, let them have a chance.
My lord.
Let them have a chance of
My lord.
filing a
My
reply.
lord, no problem.
I'll learn counsel for the matter comes up for orders on the interlocutory application filed on behalf of the respondent number 11,
10 and 11.
10 and 11, seeking vacation of the ad interim stay order dated
26/6.
26/6/2023.
26/6/23 passed by this court. Land counsel for the appellants prays for and is granted 3 weeks time to file a reply to the application. Interim order shall continue till next date. You are not supposed to quote 2263 in your application.
Oh, my lord.
Is not required.
Exactly, not required.
Why? Then we need not, even if we don't extend, the order continues. 2263 has the automatic effect of vacation in 14 days.
It is on default, in default.
Yes,
Yes,
but
in
you don't file the application under 2263.
Actually, what happened, my lord, it is not, my lord, not taken up by the computer. That is why, my lord, it has to be some, that was the problem, my lord.
If you are saying so, the registry officials must be listening to this argument. They'll rectify.
Lord, so one thing, the order was passed until further order.
Yes, so there's no need to extend
No.
a list on 22nd November.
My lord.
So 3 weeks,
Okay.
time, only time to file apply.
Item number 3.
No, they were directed to take action on whether any seat, my lord, was vacant.
Last seat has gone, Mr. Ganguly.
No issue, my lord. My contention remains that, my lord, even next year I can be accommodated.
Yes, of course, of course.
Maybe, my lord.
So we'll issue notice.
My lord, it may be-
Let some appearance has already been put in.
Yes, yes.
So let them,
Learned AG appeared, my lord.
Mr. Saikia is probably now engaged in some other court. So let him come back. Mr. Saikia, request is made to adjourn the matter on behalf of Land Advocate General, Mr. Saikia. Name of the presence of Advocate General Assam shall henceforth be reflected in the cause list, re-notified on 8th November.
Item number 5.
But we have preferred appeal against the order dated 22. Lordship will find the order at page 130.
What was the controversy?
Well, controversy is the learned single judge has directed the authorities to give the regular benefit to the petitioners, great petitioners, with effect from the date when they were appointed temporarily in 2016.
Benefit of what?
Benefit of regular pay scale and all other benefits. But we say that they were appointed temporarily, and after the concurrence of the finance, that finance department concurrence we have annexed in the affidavit in opposition. After that, they have been given the regular benefits. We prefer a review petition. Review was also dismissed, and therefore we are before your lordship. The affidavit.
Let's read the finding, please.
The finding of the honorable court starts at page 138, para 15. The rival submission of the learned counsel for the parties have been considered and material placed before the court have been carefully examined. The issue which call for a determination is whether the initial promotion of the petitioners to the post of supervisors could have been made on a fixed pay and tenure, and as to whether such promotion could have been treated as mere engagements. As a corollary, it is also to be decided that if the principal issue is held in favor of the petitioners, from which date the petitioners are held to be entitled for to the benefit of regular supervision. To decide the opposite issue, it would necessary to go back to the basis of filing present petition, which is the communication dated 28/4/1995 of the Government of India. By the said communication, while the government was considering increase in the honorarium and benefit of the Anganwadi worker, a decision was already taken to reserve 25% post of supervisor for selection from Anganwadi workers who are matriculates and having minimum 10 years experience. Even assuming, for argument's sake, that the contents of the said communication is not a guideline.
So generally, the minimum pay scale direction could have been given, but regular pay scale we also have. So
Anganwadi workers, the Honorable Apex Court has already held that they are not holding any civil post. They are not in post. In fact, there is a notification of the government of Assam.
So let's issue notice.
Lordship.
Notice of this interim prayer. Issue notice of the writ appeal as well as of the prayer for interim relief. To the respondents, steps for service be taken in 2 weeks, thereafter process be issued. Get them served, thereafter we'll consider it.
Item number 6,
Please, your lordship.
Yes.
So I'm challenging the imperial order passed by learned single judge, which lordship will find in page number 12, lordship.
Page number?
12, lordship.
Yes.
The main controversy here, lordship, here arises. The initial settlement order issued to the writ petitioner was illegal, which was issued without NIT, lordship, and which was cancelled by general order, lordship. And arising out of that case, lordship, in a coordinate bench, this the learned singular, while passing this order, which is in page number 12, the investment part, which they have reared the fees, had allowed them to take out the fees, lordship. Here, my only grievances is that, lordship, by allowing them to take out the fees will amount to sanctifying the original illegal order, lordship. So that part is before this appellate court, lordship. This issue, the coordinate bench has rejected their prayer of investment in another cases, lordship. That for this investment part, the petitioner has the option, if they have legality, to approach the civil court. And learned appellate court did not interfere that matter, and it is pending here before your lordship. Your lordship, kindly go through the order, into an order, lordship.
There are four.
Learned counsel, when upon instruction, has submitted that the petitioner is no longer interested to pursue a relief or continuation on the said fishery for any further term. However, the orally modified the prayer, the learned counsel is that petitioner may be allowed to leave the fishery along with the fish which he has harvested in the 3 tanks of the concerned fishery by submitting that those fish have been released by the petitioner at his own cost. Then the proposal was initially agreed by the petitioner number 2, which was recorded in order so and so. According, the order was passed by the MDA. However, later on the said order was recalled by the order so and so MDA FDC. Park on the learning standing council FDC has referred to the affidavit and filed by the respondent. It has submitted the authorities have realized that the settlement of fishery was made in favor of petitioner without adhering to any well-established norms of settlement of the government largesse, and that the settlement of the said fishery was made without inviting any tender process. By producing records of it is submitted the said was government asset and thus created out of government fund expenditure under IDF. It is also submitted prior to settlement of fishery, it was settled to another society by referring to the decision of the court in the Mahmood Hussain AFDC, as well in decision of the court in Timothy Multipurpose Society. This is so and so. It was submitted the state to cases arising out of same order, by virtue of which the settlement of fishery with the petitioner was cancelled, but in respect of the other fishery, it is submitted that on a conjoint reading of both the decisions, it will emerge that if the settlement holders were aggrieved by the non-refund of investment, they would have liberty to approach civil courts for any claims they may have regard with the investment or with regard to loss that may have occurred to them on account of fault, if any, of the AFDC, and that court was disinclined to interfere the impugn order of cancellation of the fishery.
Para 7. It is not denied that the fishes were reared by the petitioner.
Para 7.
So, all right. So he is reaping the benefits of his own harvest. What is wrong in it?
Lordship, I do not have any objection, Lordship. Then my only contention is that, Lordship.
Yes.
Initial order of settlement.
That was illegal, assuming, but acting on that order,
Lordship.
he started harvesting the fish.
Yes.
There was a persisting settlement in his favor when he harvested the fish. So all he is asking is that let me take out at least the fish which I have harvested. What is wrong in that order?
Lordship,
there is an equitable relief.
Lordship, if it does not interfere with the appellate court order, Lordship, which is pending before you, Lordship, kindly go to page number 152, Lordship. 152, Lordship. This is arising out of that single bench order, Lordship, which is before your Lordship, before the appellate court, Lordship.
Page
152. Of the, this is a common judgment, Lordship, which I am referring as I referred, Lordship. That the petitioner had pleaded that pursuant to the initial settlements, they had made huge investment for development of fishes.
Yes.
Question. And for this fishing activity, the said claims being disputed.
So investment towards immovable assets, yes.
No, investment, this was referred as a fishes, Lordship. And again, Lordship.
Development of fisheries, not for the fishes they have harvested. The learned single judge has made a difference between immobile property and movable property, rightly so. Thank you. No interference. Dismissed.
All right. All right. Lordship, may I pray, Lordship, one simple prayer, Lordship?
Yes.
While dismissing that, this order may not interfere with the other appellate order which is pending before your Lordship.
Which appeal?
Lordship, here in the similar manner, the investment part is pending before your Lordship.
All right, we, the learned single judge has himself distinguished that two facts are admitted, that the fishes were harvested by the respondents
Lordship.
under an order of settlement, which has subsequently been quashed or reversed. So fishes are mobile property. They can take them out. Regarding structures, whatever they have enacted, for that they have to go to the civil court. Single judge has also observed that. So what is the harm coming to you? You're not facing any harm at all.
No, we are not facing only the initial order. My only concern is the initial order.
We are just affirming the order whereby they have been asked, permitted to take out the fish. Thank you.
Okay, Lordship, not
No clarification required.
no, not the order. I'm for the order. Initial order is bad, Lordship.
That is qua immobile assets. This is restricted to the fish they have put in.
Not related to, yes.
Then why do you need any further explanation, clarification? Okay, thank you.
I would like to.
Item number 7.
May it please your Lordship.
Yes, please.
This, my lord, Government of India to provide, my lord, uninterrupted power supply in a rural part of the India, my lord. Launch a scheme naming Dendayal Upadhyay, my lord, Gram Jyoti Yojana. Under the said scheme, my lord, the power department, the government of Assam and IPDCL, my lord, they sanctioned a project, namely manufacturing of 7.5, 8.5 and 9.7 mm, my lord, pre-stage concrete tools, my lord. And that, my lord, and that project, that work, my lord.
All right, you have come out with before this court after giving a representation to the CMD of the ASCB. Let them give them some time.
Yes,
Your
ma'am.
representation is of 21st September.
Yes, ma'am.
Wait for a while.
Yes, ma'am.
Then why you're coming up in such a haste? This PIL has been filed by the petitioners with the following prayers. First off, it is an admitted case that before approaching the court, the petitioners had submitted representations to the respondent authorities on 21st September 2023. We feel that the writ petition has been filed with undue haste because the officials concerned have not been given proper time to address the representation filed by the petitioners. Thus, the petitioners are given liberty to present a copy of this order to the authorities concerned, along with a fresh representation for ventilating their grievances, whereupon, it is expected of these authorities to objectively consider and take appropriate action upon such representations. A speaking order shall also be passed and communicated to the petitioners within a period of 2 months from the date of submission of a copy of this order. In case, if thereafter, the petitioners are still aggrieved, they may approach this court afresh by way of a suitable petition. The instant PIL is disposed of with the above observations and liberty.
All right.
Item number 8.
May it please your Lordship, my lord. Lord, in this matter, my lord, on the last occasion, your Lordships, my lord, enlarged the scope of the PIL and implemented state of Nagaland and Mizoram also in
The
this.
problem is that it is my mistake. I don't know because the copy has been served in my office. Where it has been, I don't know. But one thing is there, I hurriedly have asked them that whether they have taken say 3 things which your lordship has asked for. Whether CCTV cameras were installed in the Olla police station, it has been done.
Okay.
It has been done. Just now I have asked them, it has been done. But then storage capacity of the police station, 1 month center, they will give me information. I think that the best way is to file.
All right, you file the affidavit in the next.
I think an affidavit has to be filed.
Mr. MS T. Crow and Additional Advocate General Mr. D. Das and Advocate General Mizoram, assisted by Mrs. T. Crow. For the Nagaland, sorry. Mizoram and Mrs. T. Crow, representing the state of Nagaland. Pray for, you also want time, pray for and are granted 4 weeks time to file an affidavit in compliance of the directions given by this court on 30th August 23.
Right.
List.
Look, so far as state of Assam is concerned, Milord, they have filed an affidavit on 1710. Milord, para 3 of the affidavit, your lordship will kindly have a look. Milord, they say that out of the 31 prisons in the state of Assam, 30 prisons are equipped with biometric devices where capturing of prisoners' biometrics are also in place. Firstly, Milord, this data is perhaps to be incorrect, or they will be able to clarify.
Maybe you can give a small response. Maybe you offer a small response note. If any discrepancies are there.
Yes, Milord, page 96.
All right,
Milord,
where's the
they have-
affidavit?
they have-
We don't have the benefit of the affidavit.
Oh,
as a
I'm
matter
sorry,
of
Milord.
It's not there.
Milord, I'll address your lordships on the next date, Milord.
Yes.
Because oh, this 3031, Milord, because their annexure says all the
E-prisons,
31
what has happened to e-prisons, madam? Okay. Okay, how much time would you need to do that? Okay.
Milord, there are two issues. First of all, Milord, the e-prison application is not up to that mark that it can verify the fingerprints of the prisoners, number one. Number two is that, Milord, there is a time lapse of 24 to 48 hours. These two aspects are there. It's not real time.
All right. Mr. D. Das, Mr. H.K. Das, Standing Counsel, Guwahati High Court, points out from the affidavit filed on behalf of the state of Assam that the e-prisons app is not properly functioning in real time, and that the biometric data there is a gap of about 24 to 48 hours in collating the biometrics data of the prisoners. First up, MS, your good name, madam? R. Barua, associate to Mr. D. Saike, Advocate General Assam, submits that the updating of the e-prisons act, process of updating the e-prisons act app is underway, and the issues are likely to be ironed out within next 4 weeks. List on 29th November. All right.
Item number 14.
Yes, please.
Unfortunately, two names were left out by the department, my lord. They have made the letter to the authority, chief engineer also, the agreement, that is our mistake that two names were not sent to regulation.
Yes, Ms. Knox.
Lordship has directed us to obtain the instruction as regard the earlier honorable court order. I'm told that the executive engineer has already sent all the entire.
That's
thing
what
to
when council says, Mr. Biswas is saying so that the department has already realized the mistake and forwarded the names now.
It is with the highest authority in the department.
All right. This court is informed that names of the appellants herein were inadvertently left out in the list of
regularization.
But I am talking about the appellants of the other writ appeal, my lord. Lordship has directed us to take the status of the writ
But
appeal.
Mr. Biswas says that he has information that now names of these appellants have also been forwarded.
Yes, same.
Mr. Biswas submits that he has been informed that names of the appellants herein have also been forwarded. There's one appellant. Appellant has been forwarded for regularization, ex post facto regularization in tune, in sync with the regularization of other similarly placed employees. It's not to take instructions in this regard. List after 4 weeks.
Leave it on.
Item number 16.
May it please your lordship.
Yes.
Lordship, by the order dated 22/9/2023.
You have got the
Lordship-
reports now?
No, my lord. Neither the reports have
Where is
been.
Mr. Sharma? This matter has been,
And-
Mr. Sharma,
And no affidavit has also been filed regarding the latest reports or tests which are, if.
why are you
all have
taking
been
these things so
conducted.
lightly?
My lord.
This
we had- that
deals with
part-
the health of citizens.
My lord, this, in this case, my lord,
Huh.
the department has take up this issue very seriously and sincerely doing all these things.
But you are
Hey,
supposed to
please,
provide
reports,
copies
my
of the
lord.
reports.
My lord, reports here is here, my lord.
Oh, this order was passed on 22nd September.
My lord, that I have received the original records, my lord, therefore to place before this honorable court, my lord.
We had asked you to provide copies to,
That has been provided, my lord.
no,
My
that's
lord,
what
that
she's
has been
saying.
provided, my lord.
Lord, it's.
That has been provided, lord, notice is here, my lord. That has been provided.
She urges that detailed reports of the consolidated chart.
That has been provided.
When did you provide?
That was provided on 13/6, my lord.
Oh, that was just a chart.
No, my lord,
No,
thereafter, my lord,
this is-
entire.
This is another letter. I will just seek instructions from my colleague, my lord. Where has
That
he
was
kept it?
received
Because
by-
it's not in the file. His signature is here, my lord. I admit to that.
Yes.
It is his name.
Mr. Sharma submits that the copies of the reports referred to in the order dated 22nd 9/23 have already been provided to MS P. Agarwal and counsel representing the petitioner. Our Mrs. MS Agarwal submits that it seems that these reports were collected by our associate and I have not been tagged with our office record. Needful bit, she may, Ms. Sharma may provide an extra set of the reports to MS Agarwal.
My lord, it's okay. I'll first clarify with my.
Doesn't
colleague
matter,
if
he
it
can
would
give
be
you an
possible.
extra.
Mr. Sharma.
MS Agarwal must collect an extra set of the reports from Mr. Sharma. Okay, what else was to be done?
My lord, affidavit was supposed to be filed with
Affidavit,
regard to the
para
latest,
4.
latest test
My lord,
conducted.
so far, my lord, this case is concerned, we have received the original copies of the earlier report in separate file. And my lord,
Let's
instead of
read your,
filing the affidavit, my lord, this is a very bulky, my lord. District wise, the subsequent stage, month-wise statement of my lord, testing report.
testing reports. All right,
And
you
the-
do that. Do that.
All these things we have collected, my lord. It is very difficult to file affidavit because that is why I have received the original record.
Just give a chart, what the reports have come out with, the summary of the reports.
My
You can file a summary.
summary I can file, my lord, because my
Do
lord,
that.
all that time, my lord, my learned friend asking for
No,
the report.
Hey, if
This
you go
report-
month by month or quarterly reports, then you can't be expected to
Yes,
file
my lord.
the entire bulk here.
My lord.
So you'll have to provide the summary only.
My lord, what I would like to submit, my lord.
Hmm.
Yeah, pursuant to this order.
But what have you done thereafter? Because she pointed out that in some cases, the pollutants were of very high level, which are alarmingly high, we would say.
It is at page 77, my lord.
Read. Mr. Sharma.
My lord.
That is why we had asked you regarding this very para 4. Come to page 77, please.
To that aspect, my lord, I would like to, my lord, point out from the affidavit filed by the, my lord. Respondent,
This is your affidavit only.
my lord.
This is your affidavit regarding presence of formalin, cadmium, arsenic.
Yes, my lord.
So you were to take follow-up action.
That
What has
follow-up
happened
action
thereafter?
We have taken, my lord, and after my lord follow-up action, my lord, we have, my lord, distributed the testing kit to all the district.
Hmm.
And awareness came to us, my lord, held in the all the district. And
Mr.
now,
Sharma, you have to
after my
tell-
lord, after that,
You have to reach to the source,
my lord,
where from these contaminated fish are coming,
my
and
lord,
you have to strike at the source.
my lord.
Otherwise, simply detection, how would it help you?
My lord, in fact,
You have already detected once. What measures have you taken to stop the supply of these contaminated
in
fish?
fact, my lord, nowadays, my lord, the supplier from the originated, my lord, place,
Mm,
they have, we have insisted to, my lord, submit a testing certificate from the
Okay.
source.
Okay.
That has been, my lord, done,
Where is that indicated?
my lord.
Where that has been
One
indicated?
certificate, my lord, I can produce, my lord.
So why don't you bring that fact on record?
My lord,
If you are asking for a testing certificate
Right.
on the raw material, the material supplied, that should serve the purpose. Right, that's sort of an audit of what goods are being supplied.
and
Place that on record.
that-
Mr. Sharma, please for short opportunity to file the affidavit in terms of order dated 22nd September 23.
consolidated affidavit.
Consolidated affidavit. List on 17th November.
Obliged.
Deeply obliged.
Hmm. What has happened to 17 and 18? That affidavits have come? Okay. Supplement.
Supplementary list, item 19.
Hmm. Where is the order? Order. Mr. Bora,
Yes, my lord.
we prepared an order.
Yes.
Both of you have a look at it.
Yes.
The writ appeal is allowed. Give them the order. They can have a look at the order. If there's any change. You have a take your time, both of you sit together and read the order.
Yes.
Yes. Item number 20.
May please lordship, lordship, it will file against the Ranat Singh Ajad order dated 29/9/2023, my lord. My lord, the fact is that, my lord, the petitioner belongs to scheduled tribe community, my lord. She appeared in the net, my lord. She qualified in the ST seat quota, my lord, in the state quota. My lord. Accordingly, my lord, one annexer Roman 5 certificate is required, my lord. That was, my lord, I went to the office, my lord, that they issued me. Next day, they have withdrawn, my lord. Then I approached the honorable court, my lord. Uploaded these documents, my lord. I kept a photocopy, my lord, that was uploaded, my lord. Accordingly, my lord, my name has been appeared, my lord, in a provisional list. And I took admission in the Nagaon Medical College, my lord.
Then what happened?
Thereafter, my lord, the honorable court director, my lord, verify, my lord, whether I belong to scheduled tribe community or not to the SLC, my lord, state level selection scrutiny committee, my lord. The state level scrutiny committee, my lord, on 28 submitted report, my lord. This is inconclusive report, my lord. They could not verify, my lord, whether
Inconclusive.
my lord.
Okay.
Thereafter, my lord, the matter was taken on 29, my lord. On that day also, my lord, I have been directed to appear before the, my lord, committee, my lord. The order was, my lord, passed on that day, my lord, Friday, and Saturday, my lord, after evening, I got the certificate copy, my lord. Then I tried to approach the authority, my lord. That time, my lord, the SLC was not sitting, my lord. Thereafter, my lord, my admission was provisional up to 30, my lord. The college authority, my lord, asked me to not to attend the classes, my lord.
Okay.
And thereafter, my lord, I made an application to the, my lord, chairman of the scrutiny committee, my lord.
Okay.
So my matter may be considered, my lord, immediately because.
What is the status of our seat?
My lord. That is filled up, my lord, because.
Filled up.
Yes, my lord.
How do you say so?
No, by other candidate, my lord, because within the cutoff date, my lord, her status could not be verified, my lord, within 39, my lord.
What
So
is
by
filled up
other
now?
candidate, that has been duly filled up, my lord.
Then what can be done, Mr. Sarania?
My lord, actually.
You have to implement that candidate. If you are higher in merit and your certificate is verified, then perhaps that candidate would have to lose the seat. But so far as yet, as on date, the situation is that another candidate has been admitted in your place.
My lord, lordship pass an order, but I'm allowed to continue my for till my lord decision of the
Okay,
central committee. My lord.
two candidates against one seat. How that is possible?
My lord, already I have admitted my lord professionally.
Whatever,
Only
sir,
because of that,
whatever.
My lord,
Whatever, but situation now which has developed is that pursuant to your certificate not being verified, your admission stands cancelled and another admission has been given. So that candidate, there can't be two candidates sitting on one seat.
that is true, my lord. That
Then-
is true. That is true.
So you have to meet
But
that
my
candidate.
my lord did certificate, my lord, the scrutiny committee, my lord, they have not come to a conclusion.
We
yet.
understand that conclusion of the single judge may be wrong, but whatever the situation be, another candidate has come in, who is not a party before us. You will have to implement.
My lord, I request my learned friend to give the other candidate name. Otherwise, my lord, I am
No,
not aware of that.
You will have to give the name.
With the address.
We will record your
It is
submission.
not possible for me to get the names.
We will record your submission, come out tomorrow with the detail. Issue notice. Mr. So and so appear on behalf of the respondents. Mr. Bora makes a statement at bar that pursuant to cancellation of the certificate, STP certificate held by the petitioner who had been appellant, who had been provisionally admitted in the first year MBBS course for the year 2023, her admission was cancelled and another candidate has been admitted in her place. Mr. Bora to keep the admission notice of the said candidate available for the court's perusal. List tomorrow. Tomorrow you will find out.
Yes, my lord.
My lord.
Item 22.
May I please, Your Lord?
Yes, please.
My lord, matter relates to, my lord, the appellant was selected and appointed as an assistant professor, my lord, in the Department of Education in the Pandit Deen Dayal Upadhyay College in the district of, my lord, Karimganj. Now, my lord, what has happened, my lord, my selection and appointment was put into challenge before this honorable court on the ground, my lord, that I am not a, my lord, permanent resident of the state of Assam. So therefore, this certificate of the reservation, my lord, which had been produced, my lord, cannot be taken into account. The first round of petition, my lord, and that petition was dismissed. With a, my lord, clear observation, my lord may be pleased to find that, my lord, order.
Page.
Yes, my lord, the first order, my lord, may be pleased to find is at page, my lord. 101, my lord, Annex 2. This is the interim order, my lord. The final order is that.
Just a moment, just a moment.
Yes, my lord. Is that page?
In this case, madam, for responder 7, my lord, I'll appear, my lord, and one case, my lord, we have filed another appeal, my lord, against the said judgment of the single judgment. There's a review, this is the one part, my lord, the advertisement part, my lord. So it is filed on, my lord, 9th October 2023, my lord. So, my lord, may I pray this? Another appeal is pending, my lord, the appeal 110, 2022, my lord. Related to the same matter, my lord. Before this honorable court, my lord.
Yes.
My lord, my lord, the first writ petition, my lord, filed by my senior friend, the final order starts at page 149, my lord, the operative part.
All right, let's have their appeal also.
Yes, my lord, they have
Tomorrow?
the cross appeal, my lord, only, my
Tomorrow?
lord, my humble prayer, my lord, is that as, my lord, my appointment has been interfered with by the, my lord, learned single judge, and there is an order of advertisement also, my lord, can the status quo as on date?
Advertisement has been issued
No,
today.
no, my lord.
Then what is the problem?
Yes, Lord, they are going to issue very shortly as per the
Tomorrow,
direction
my lord,
of the.
tomorrow, my lord, this. Tomorrow, my matter will come.
Tomorrow, let's hear you tomorrow.
My lord.
Tomorrow.
My lord.
And my lord,
List, Writ appeal number, you give a permissions, it is a numbered appeal?
My lord, it is already filed, my lord, probably it will be numbered today, my lord. It is filed on nine.
It can't come up without being numbered. There might be some defects, we don't know.
No, my lord, defect, there is, it was detected defect not filing the affidavit in writ appeal, my lord. Yesterday it is cleared, my lord. Yesterday cleared, my lord.
Mr. Mehdi appearing for the respondent number 7 submits that he too has filed an appeal, cross appeal against the very same impugned order dated so and so passed by the learned single judge. And that all defects have been cleared in the memo of appeal. Let the said rate appeal be numbered and listed tomorrow along with the present rate appeal number 402/20.
Another appeal, my lord, is pending, my lord, W 110, my lord. 2022, this, my lord.
What is that about?
My lord, this, initially I challenged the order of the learned single judge, my lord. Yes. Yes, yes.
On the basis of the order.
Yes.
That appeal has already, that we'll dispose of it in
Yes, my lord, on that.
appeal number. Sir.
Yes.
Okay, tomorrow.
Well, copy will serve today itself.
Copy, provide the copy, Mr. Boyan, immediately.
We'll exchange, my lord.
Yes,
We will
today,
serve a copy
today.
and-
Yes, of course.
My lord, definitely.
My lord.
Item 19.
Seen the order?
Yes,
Okay,
Yes.
all right. Rate appeal is allowed.
Objection.
Daily list for hearing. Item 17.
ये अंदर भेज देना.
Teachers case, my lord, where 2019.
Today morning, I have filed the affidavit. To bring on record the minutes of the screening committee. There is no minutes as such, my lord. There's a cabinet memorandum. I have explained in paragraph 2, my lord.
So let us take it up to Puja vacation then. What is the urgency? 2022 matter.
Yes, my lord.
Mr. Katiyar has filed.
19 order has been interpreted, stay there. Order is that, my lord, if she is working, the salary has to be paid. So your lordship own judgment is there, besides the judgments of the Supreme Court and other courts, my lord. If she is working even.
We'll take it up immediately after opening. The Mr. Katiyar has filed an affidavit yesterday, which is taken on record. Let the rate appeal come up for hearing on 9th November.
Obligation.
Your lordship's own judgment is there.
Item number 18.
Yes.
Lordship, Mr. Airby is on lag at another court. Could it be taken up after the vacations? I was to get some instructions on, they were empty candidates who wanted to apply for Arabic. I would ask for the written instructions, my lord.
All right. Mr. Mazumdar appearing for the Education Department. Placed for short opportunity to complete his instructions. List on 20th November.
Item number 1.
I have seen this, my lord. And immediately I reacted, I asked the law secretary, JAD, the deputy commissioner.
So do you
Why-
propose
why-
to resolve it at your end or you need our
If
intervention?
I am there, after I don't know, so I'll try to do it. I'll try to resolve it. And what I have been told by deputy commissioner, the two cell, there is proceeding cell and that have not been shifted as on date.
Have not
Lockup
been
cell.
shifted, but the order exists.
Immediately. That order is that immediately.
That's what that has been told, my lord. That has been told, that has not, because for the purpose of election. 2 rooms already out of the 3 rooms, as I have been told, 2 rooms has already been with the bar.
Mr. Das, we will call this officer in the court personally.
Yes.
Otherwise, otherwise, you know how the resolution.
No, that's true, my lord.
Then,
My lord.
once the
whatever,
premise
I am
has
a
been
part of a-
allotted,
I am a part of a bar, my lord.
yes, once the premises has been allotted by the cabinet decision, who is the officer to say that you shift these things?
No, ultimately commerce and industry department, my lord, which are geology mining, they have to hand over to law department.
That's right.
Yes.
But the officer is no one to say till that new building is functional.
Yes.
He can't say,
That's true, man.
okay, yes. So where is the order, Mr. Manta?
Page,
Is
my
the
lord, annexure 5, my lord, annexure 5, my lord, page 17. Order the 6th October 2000.
It is learned. What kind of information the officer gets? From where?
It is learned from the building and commercial
that's true.
department. Some stay order has to be, my lord.
So should we right now direct the personal presence of the officer, or you want?
The only difficulty that there is an election on 7th. That's 7th.
And the officer has to apologize in writing. Interfering in the affairs of the judiciary is no business at all. Without even taking the restraint to confidence. Neither the district judge was informed, no one.
No, that's
Randomly,
I've seen.
the order is
That I've
passed.
seen.
Online, the instant. So motor PIL is registered. In reference to the, on the basis of a representation dated 12/10/23 submitted by the President Mizoram Bar Association.
Before your lordship, I'm sorry.
No, please.
Your lordship can give a direction, direct direction that it should be handled. That will become a more.
That also we will do,
Because
but for the
also
present,
it's
for the
approved.
timing, this direction given
No,
by the
that
officer
your
to
lord-
shift.
No, that's not correct, my lord. But your lordship will give a direction that immediately.
Yeah, we will do that. We will do that.
Yes.
But for the present, we are concerned with this order of 6th October.
Yes.
Representation dated so and so,
12/10.
raising a grievance regarding the order dated
6th October.
6th October 2023, passed by the Deputy Commissioner Lunglei District, Mizoram, whereby, the officer is directed that the prosecution branch / cell of the district court, including the lockups currently housed in the first basement of the Deputy Commissioner's office, shall be shifted to the building of the Commerce and Industries Department immediately, and the vacated floor shall be renovated for the office accommodation of the election observers, income tax officials, and the media monitoring cell within 2 weeks from the date of issue of this order. The aforesaid order has been passed on the premise that the building of the Commerce and Industries Department, presently utilized by the Zonal Geology and Mining Office, has been occupied by the District Court, Lunglei, since 27/9/2023. However, the fact remains that possession of the said building has till date not been handed over to the District Court, Lunglei. Mr. D. Das, Advocate General, submits that in order to facilitate the expansion of the District Court building, the cabinet yes. The Council of Ministers of State of Mizoram, in its meeting dated 12/11/22, 22/11/22, had approved the proposal for allotment of the land and building of the Commerce and Industries, Lunglei, for the construction / expansion of the District Court building. However, till date, the matter has not been finalized and the possession of the land and building has not been given to the District Court. This court is apprised that the Deputy Commissioner Lunglei has issued a certificate of land availability certifying that 513.84 square meters of land was available within the Deputy Commissioner's complex for construction / expansion of the District Court building. What do we? But that building is also in the same premise. Next door, okay. Okay. In that commercial. Mm. Mm. What did they- Ms. Das submits the till date, though the, Mr. Panta submits that though the Bar Association has entered into the two rooms of the Commerce and Industries Longli, a building of Commerce and Industries Longli allotted to the district court, but by now, as of now, proper lockups, neither proper lockup facility has been constructed, nor any room has been allotted to the prosecution branch. Thus, he urges that the order dated 6 October 23, passed by the Deputy Commissioner Lunglei, to the extent, the prosecution branch of the district court and the lockups were directed to be shifted to the directed to be vacated, requires intervention by this court. Ms. Das, Learned Advocate General, assures that efforts are underway to ensure that the building of Commerce and Industries Department, which has been allotted to the district court, allotted for the construction / expansion of the district court building by virtue of the cabinet decision dated 22/11/22, will be refurbished so as to meet the requirements of the district court at the earliest. Commerce and Industries are already, he further assures that the Commerce and Industries Department shall also fully vacate the building within next 30 days.
If your lordships gives a.
This court is apprised that the Office of Commerce and Industries Department is not functioning in the said building, but on the other hand, is there, brother? Look at page 5.
Mining and geology.
This court is informed that in part of the said building, the zonal office of the geology and mining is functioning, whereas, the two basements are occupied by the staff of the Commerce and Industries Department, Lunglei. In view of the facts noted above, we hereby request Mr. Das, the Advocate General, Mizoram, to ensure that the complete vacant possession of the building allotted to the district court by the Cabinet Council of Ministers, State of Mizoram, is handed over to the district court not later than within a period of 30 days. 45 days from today.
45 days.
In the meantime, the effect and operation of the order dated 6 October 23, to the extent, a direction was given to vacate the prosecution branch cell of the district court, including the lockups, shall remain in state.
And Commerce and Industry Department, they should hand over immediately to the law.
That is what we have directed you
Yes.
to ensure. List after 2 months. To district judge only. To district judge, not to the law department. To the district judge.
Only there is a written, there is a law department. To hand over to the law department, they have used this word.
We have modified it now.
Yes.
The possession of the building upon being vacated shall be handed over to the district judge.
Yes.
For pronouncement of judgment, item 1.
For part two IPC. Accordingly, the conviction of the accused is set as under section 302 is set aside and is convicted under section 304 part two IPC to undergo imprisonment for 7 years. The sentence of fine is upheld. The period of detention of the accused during investigation and trial is set up with the custodial sentence.
But may I say something, Malad? Submit something, Malad?
Yes.
As per the cause list, Malad, he has already undergone his.
He'll be released automatically.
If that
He'll
is
be
accepted.
released automatically.
Malad.
The judgment will go and then he'll be released.
Obligement.
But the fine part, he'll not be automatically released.
Malad.
The fine part remains. So only on payment of fine. Otherwise, they'll calculate the default sentence, then release him.
Obligement.
Item number 2.
In wake of the discussion made here and above, we are of the firm opinion that the impugned order dated so and so passed by the learned single judge, accepting the writ petition number so and so of the respondents numbers 1 and 2, and setting aside the order of the NCLT Guwahati bench does not suffer from any infirmity warranting indifference of this court. As a consequence, the writ appeal fails and is dismissed as being devoid of merit.
File your place.